So it's James from Community Legal Centres Queensland here. I begin today's session by acknowledging the traditional owners of the lands on which we gather through the magic of technology. I'm here in the offices of Holding Redlich, and so I acknowledge the Turrbal, the traditional custodians of the area that we call Brisbane. I acknowledge though that there are people joining in this webinar from across the state, and so we acknowledge all First Australians, their elders, ancestors, leaders, and any Aboriginal and Torres Strait Islander people who might have tuned in today. Really pleased that you've been able to join us to learn more about some of the legal issues that might be faced by community legal centres clients in relation to their interactions with Queensland schools. From time to time, parents or possibly even students are coming into your centres with a range of legal questions or queries, and so it's great to have Rachel and Eddie here from Holding Redlich to provide a pretty broad sweep of the landscape of some of the legal issues that might arise. Now, we don't have any visual presentation for you today. We're hoping that this will be a fairly conversational style webinar, which is quite different to our usual format. So there are a couple of ways that you can ask questions, and we encourage you to do that over the course of the next hour or so. Two ways that you can ask questions. One is to press that button that looks like a hand on the control panel on your GoToWebinar software. We'll see something that looks like a hand popping up at our end. You'll be able to unmute your microphone and you'll be able to ask a question through speaking through your microphone or your phone. The other way that you can ask a question is to type a question into the questions box on your GoToWebinar control panel there. We'll see that pop up at our end, and I'll paraphrase or read your question out to our presenters today, and they'll be able to respond that way. So ask your question either by pressing that hand button or typing a question into the questions box. Hoping to have an audio recording of this session when we finish, technology willing, and if there are any questions that our presenters need to take on notice, then we might distribute answers to that in the next few days. So without any further ado, let me hand over to Eddie Burke and Rachel Drew from the employment team here at Holding Redlich, and thank them both for their support for this webinar, which I'm sure is going to be really informative for many of you working in this space. Over to you guys.
Thank you. Good afternoon, everyone. Rachel speaking. The types of topics that we're going to have a look at today, we've used a bit of an educated guess as to what community legal centres might be asked in relation to school law. So we're going to look at disability standards and exceptions in the educational context. We're going to talk about enrolment and suspension and exclusion, particularly from state schools. We will be talking about schools engaging in family law to the extent that we're able to. We're not family lawyers, but there are a few things we'll be able to tell you about that. Looking at obligations on teachers around child safety concerns, and then finally looking at defamation and Facebook generally in relation to school areas. Eddie and I both are employment lawyers, and one of the significant areas of practice for us is in relation to teacher employment. So we do a lot of work in the space of teacher employment. So a lot of what a lot of our experience is around how teachers engage in terms of schools. So we've tried to turn that around today, because more likely than not you won't be speaking to teachers in the community legal centres. You'll be speaking to the parents and the students. We do want to get as much feedback from you through your questions as we can, so please feel very welcome to put your hand up or type a question so that we can get that feedback and understand better the type, simply answer your questions today as well. So I'll start with the disability, talking about disability in education. Eddie and I will probably do around about 10 to 15 minutes each on those 4 topics. Plan is to finish speaking by about 20 past 4, with the idea being that the next 10 minutes can be used for general questions, things you think of at the end that you haven't thought of on the way through, or anything that we didn't touch on at all through the process. So I'll start with disability discrimination in education. There is a Commonwealth system of disability or anti-discrimination legislation, particularly through the Disability Discrimination Act, and there's also a state system of anti-discrimination legislation. The two sets of legislation are very similar, and both of them apply in education. In addition to the legislation, there is also a standard, which is called Disability Standards in Education. It was first produced in 2005, and it's had 2 reviews since, in 2010 and 2015. And that document is intended to reflect a practical application of the disability law, and particularly in relation to how it applies in settings. So it's not a law. Parents do refer to the disability standards and say that a school hasn't met the disability standard. The standard is intended to reflect the law, but the law does stand alone. So disability law generally applies to a number of areas in relation to education. So it applies to whether or not the school has accepted a student's application for admission, or not a school has permitted a student to have access to benefits or programs within the educational authority. It applies to decisions around exclusion and potentially suspension of students. It can also apply to the application of disciplinary consequences to students in a school area. There have been a number of very significant cases in relation to disability and the way the discrimination law applies to one successful case was a Queensland case which related to 2 students in the same school who were both deaf, profoundly deaf students. Both students only communicated using the language of Auslan. Auslan is recognised essentially as being its own language. It's not a translation of English. It is its own language for the deaf. Both of these students only spoke Auslan. However, Education Queensland provided education in English, which was translated through sign language, and both of these children showed a very distinct lack of progress, which their parents felt had arisen as a result of them being essentially taught in a language that the students were not familiar with, being English instead of Auslan. The two parents got together and ran a federal court appeal to the decision to offer instruction in the language and didn't want to meet the cost of 2 students and wanted to continue to provide the signed English instruction for the students. What the federal court found was that the detriment to those 2 students was quite significant, but the cost to Education Queensland of having to provide an Auslan interpreter was not so out of proportion that they ought to be entitled to avoid paying that. And the court essentially ordered that the provision of education in anything other than Auslan to those 2 students was discriminatory. And that has led to a change in Education Queensland's practices around the availability of Auslan as a language being used in schools, and particularly for deaf students in schools. There have been subsequent cases to that where a student with a disability has not been successful. There's been a number of quite significant cases. For example, there was a case involving a couple of students who were involved, had a range of disabilities, which included some behavioural disabilities and some learning disabilities. They were being taught within a particular type of program that was being offered this is a case in Canberra. The school was, in fact, it was a state educational or territory educational facility, was offering education through a particular program which was able to address the behavioural and learning disabilities of the students. It was decided that the costing for that program, it was too expensive. It was costing around about $80,000 for the provision of services to with either 1 or 2 students in that case, compared to the overall, and that as compared to the overall budget for special education being $50,000, was decided that it was out of proportion. So the educational facility introduced a new program. The new program removed the funding that was required to have the necessary level of staffing. Essentially, it resulted in a reduction in staffing numbers and the program couldn't be offered anymore. The court in that case, different to the Auslan case, found that the cost of offering that special program was disproportionate to the benefit to the students. So unlike Auslan, where the federal court decided that which would be a pretty common complaint from parents around disabled students is either the availability of a special service or the removal by the school of some special service that had previously been provided. The Anti-Discrimination Act says that it is not unlawful for an educational authority to discriminate. So it's not unlawful for them to discriminate on the basis of an impairment if or facilities and the supply of those special services or facilities would impose unjustifiable hardship on the educational authority. So that's specifically recognising that either the cost or the level of difficulty not unjustifiable hardship applies, depends on the nature of the service, powers of suspension and exclusion. So just to deal with the general question, whether or not a student with a disability can be expelled, there is, well, it's probably better to put it in the negative, there's nothing that says schools cannot exclude students with disabilities. So any school looking to exclude a student with a disability needs to be very careful to ensure that any exclusion is being done with very close regard to the discrimination legislation, to make sure that the actions aren't being taken on the basis of the student's disability, but is being taken either on the basis of some unjustifiable hardship or some other reasonable ground for that. So I might pause there and I'll hand over to Eddie to talk about suspension and exclusions generally.
Thanks, Rachel. As Rachel said, my name is Eddie Burke, accent in advance. If anybody can understand me, tough luck, I guess. I've been asked to speak about suspension and exclusion from state schools by students, and I guess that's something that you probably deal with quite a lot. Parents coming in after their kids have been suspended or expelled from school, wanting to know what they can do to get them back in or get them into school. All of this comes under the Education and General Provisions Act, 2006, and the principal's power to suspend is under Section 281. Now, the powers and the grounds for suspension are very broad indeed. Now that will apply also to exclusions and even just enrolments in general. So I'll just go through those to give you an idea of how broad they are. So each of the following is a ground for suspension. So disobedience, misbehaviour, conduct that adversely affects or is likely to adversely affect other students, conduct that adversely affects or is likely to adversely affect the good order and management of the school, the student's attendance at the school poses an unacceptable risk to the safety or well-being of other students or of staff, or if the student is charged with a serious offence. It's also a ground for suspension if the student is charged with an offence other than a serious offence. That could be shoplifting, I guess, could be living almost. Now, the principal must be satisfied that it would not be in the best interest of other students or of staff for the student to attend the school while the charge is pending. And then to remove any doubt at all, the Act also says that it is declared that conduct may be a ground for suspension even if the conduct does not happen on school premises or during school hours. The proviso on that is that it adversely affects or is likely to adversely affect other students enrolled at the school, or adversely affects or is likely to adversely affect the good order and management of the school. So I guess what you'll notice is how broad all of that is. The principal really does have broad powers to exclude a child, but it's not a question of them just being able to kick the student out of the school on a whim or because they don't like them. There are procedures that have to be followed and they do have to justify their reasons. For example, they must tell the student and the parents the allegations and the information they're using to make their decision. They must give the student and their parents a chance to respond to the allegations. They can't tell the student that he is immediately, or he or she is immediately suspended while the principal makes a decision about the exclusion, but that decision has to be made within 20 days of giving them a letter proposing the exclusion. Now within that 20-day period, the parents can make submissions to the principal about why their child shouldn't be excluded. The student can obviously make submissions themselves. They need to have all the information around why the child is being suspended or excluded or expelled, I guess is the correct term. So they're entitled to have all of that information within that 20-day period, and they're entitled to have an opportunity to respond to that. The other thing is that the principal must take reasonable steps to arrange for the student to continue their education while they're suspended. Now that can consist of applying with materials, lessons that are ongoing, various ways of making sure that the child doesn't miss out on their education because of the suspension necessarily. One way they do that is that they supply them with what's called just a regional case manager through the Department of Education, and they have certain obligations to make sure that the student's education doesn't suffer if it, in the meantime. Now that question of whether the principal can exclude a student for behaviour that occurs outside of school is probably something that you might deal with quite a lot. Conduct which doesn't occur on school premises or during school hours can be a reason for exclusion, for those reasons that I said earlier, that it adversely affects other students enrolled at the school or it adversely affects the good order and management of the school. Now, I guess if you can use your imagination for the kinds of things that might be, it may be that they're involved in an assault outside of school, and that could be intimidating to other students. It could have been against another student outside of school hours, but it was obviously affects the management and the safety and well-being of the students of the school at the time. There are occasions when the principal must refer their own decision to the Director General of the department rather than just suspend them themselves. And again, they have broad powers there. It's when they believe it is appropriate to do so. One of the main reasons would be if there could be some allegation of bias against the principal. For example, if the student has done something that directly affects the principal or a family member of the principal, if there's any indication that excluding or suspending the child could seem to be for vindictive reasons, it should be referred to the Director General to review and to make a decision on that rather than the principal simply going ahead and do that themselves. As I said before, there's a time frame for making the decision, and that's generally 20 school days, and that begins on the day that the notice proposing the exclusion is actually given to the student. The details required in the exclusion notice is quite important, because that's what I imagine a parent would come to you with, and what you'd have to help them with in terms of responding. So it is obviously important that the student and the parents understand the reasons for their exclusion. The term reasons is defined by the legislation as being findings on material questions of fact, a reference to the evidence or other material on which the findings are based, the reasons for the decision. Basically all that means is you should get a description of what the student has done and the reasons why they're being excluded that fits into those ideas of adversely affecting the management of the school or the well-being and safety of their students. There will be an exclusion notice on the one school system, which I'm sure you're all familiar with, and that will require a principal to insert facts, evidence and reasons to back up their final decision. That's probably most of what I have to say on that. Myself and Rachel did discuss this earlier about appeals and were there any mechanisms for appeal once a student has been suspended. The simple answer seems to be no, but obviously there is a natural justice process, there is a judicial review process that can be followed, but that's extremely difficult and can be quite expensive to do. You also have to take into account that a suspension itself may only be for a week or 2 weeks, and you got to question just the practicality of trying to appeal something like that. I think this is the one that there probably will be some questions on at the end, so I'll let Rachel go on to the next topic.
I might just jump in with a couple of questions if I could. It's James from Community Legal Centres Queensland here. One of the questions that's come through, Rachel, in relation to your discussion earlier about the need for special provisions to be made for a student with disability, and I don't use that as a term of art. What about when a parent wants their child schooled in the mainstream, for want of a better word, where the school's made some judgment that some kind of alternative way of delivering the education is appropriate, but the family or the student don't agree with that approach. What rights might they have there?
That is a very, very common scenario. So Education Queensland in particular, and most schools run what is called effectively a mainstreaming approach for all special education. So there might be a special education unit in some of the larger schools, but all that unit does is coordinate any special services that are going to be provided to students. Students sit in the normal, in inverted commas, the normal classroom and engages in normal instruction in the same way as every other student does. So look, that is current educational philosophy, that mainstreaming students is best for them, that they're in the same class learning the same things as everybody else within their peer group. However, there are regularly cases where, and it's particularly in Education Queensland probably, but it probably happens in private schools too. There are situations where the teachers and admin representatives within a state education school will say to a family, your child is not suitable for mainstream school and your child should be taken out of mainstream school and should be put into a special education facility. Sometimes it'll also happen where, so it might be a smaller school, the student with disabilities is enrolled in a small school which does not have one of those special education units. Education Queensland will accept their enrolment, the school will do what it can, provide a mainstream education to the student, but it is a very common scenario that even in that situation the school will say your child is not suitable for a mainstream education in our school. We suggest you either go to the bigger school, which might be inconvenient for the parents, but we suggest it's best for the student to go to the bigger school that has a special education unit that can coordinate the services for the student, or take them to the special school where they'll get a special school program of instruction. That comes under the exceptions to disability discrimination. So as a question of law, is it discrimination for Education Queensland to say that a student with disabilities can't be enrolled in that kind of small school environment that doesn't have the SEU, or the bigger school with the SEU? Yes, it is discrimination, but does the school have the benefit of a defence or an exemption? And the answer in reality is most commonly yes, they do. Probably the most assistance that you can give to parents in that situation is just to make sure that the school has followed a fair process for assessing their child. So more likely than not, the answer is going to be, well, the school has made that assessment based on the needs of your child and the resources available in our school, and it's not going to fall in the category of an actionable discrimination. But what you can do for the parent, because it may be the parent has not been able to communicate properly with the school, there may have been a communication breakdown between the parent and the admin group. The parent may be distrustful of the admin group, and what you can do that's going to help that parent to understand why this is being put to them is to help them get some information from the school. Why is it that this student can't be educated in the school of choice of the parent? What is it about either the school's resourcing or the student's disability that the school does not feel that they can cater for that student within that environment? The cases where we have become involved in that type of thing, typically the schools do try to go through a really fair process to assess whether or not there are additional resources. Is it a question of just we put another aide in for a couple of hours a day? They do go through that process and try and get extra resources. And the ones where we find difficulties arise is usually where there is that communication breakdown. So it's not that the school's done anything wrong, it's just that for whatever reason there's been a communication breakdown between the admin of the school or even the class teacher sometimes and the parent. And the best that you can do for that parent is to help them understand why that recommendation is being made to them.
Terrific. A reminder out there, folks, that there are a couple of ways you can ask questions. You can press that button that looks like a hand, or you can type a question. Eddie, I've got a question here that I think is probably about 10 questions wrapped up in one. There's a level of complexity to it, so maybe take note.
Okay.
At the last review of the Education Act under the previous government, the term short-term suspension was doubled. Is this still current? And the parent's right to natural justice was removed for appealing short-term suspensions. And the final part of that question, which I think you're getting about 3 or 4 different things, in relation to a student being questioned by police, not charged, but just questioned, the legislation allowed that that information could be provided to the school. Is that still occurring? And do you have any sense of where these legislative changes, because it's been a fairly fluid area probably in the last term of government and in this term of government, where that's up to at the moment, particularly in light of proposed changes to youth justice system?
Look, I think the easy answer to that is to go back to the broad parts of the principle that we spoke about earlier. In terms of whether the police are allowed to give the principal information, to be honest, I'm not sure. But certainly if the principal becomes aware of or has reason to think that something has occurred, that wide discretion allows him to act in a way that he thinks is appropriate. In terms of natural justice in appealing short-term suspensions, that still exists in that parents are allowed to make submissions against suspensions and against cancellations. They can make written submissions that go to the DG of the department, but again, there's a practicality in that. The suspension begins on the day that the letter is given to the parent. If the suspension is for 1 week, by the time you get the submission in, by the time it gets to the DG, the suspension is probably over.
So it is correct that the last review of the Education General Provisions Act did rewrite a lot of the law around suspensions and around what suspensions can a principal issue and what suspensions need to go outside of the school. And yes, all of those changes are still in place. So the principal is still entitled to give notice of a suspension to a student, but there are these internal submission rights for parents. They are less sophisticated than what they used to be. So it did used to be a more sophisticated system of review within the regional office and then review by, I think it might have even been reviewed by the minister. So there is still that natural justice in there. It's different, it's a bit more low level, and it does push parents into a judicial review much more quickly, which is typically not, it's not going to be worth the filing fee to go to a judicial review. What's the policy behind that? Look, it probably was a deliberate policy to reduce the admin burden on principals for suspending students, increase their autonomy around suspension, and decrease the opportunities for parents to challenge those suspensions. Although there are rights in the Act, the parents still have the right to communicate to the department at any level at any time. So if they receive that suspension, they're entitled to go to the regional office and complain about it. They're entitled to go to the department and complain. They're entitled to go to the minister and complain. But the points that Eddie made earlier about what are the relevant factors that are going to affect whether or not the suspension stands need to be addressed by those parents. So it can't just be the parent writing nasty letters, talking about how unfair it all is. They have to address those key issues around the student behaviour, around how it's affecting the learning of other students in the school, not just how awful this is and how unfair it is that my student, my child, or the child in my care has been suspended from the school and can't access education. Okay, so I'm going to talk a little bit about family law and then child safety. Eddie and I are not family lawyers, so I can't talk about the family law. What I'm going to talk about is how the family law impacts on schools. Schools are not enforcers of family law orders. They do not even get copies of family law orders in most cases, even from the parents. It's quite common for parents to say, I have an order of the family court, but never to provide that document to the school. And we have seen a number of instances where parents have said they have family court orders when they did not have family court orders. And those things, that the examples where parents say things that aren't true to schools do make schools very wary about relying on something that a parent says without receiving a document to back it up. So they're not enforcers of the family law. They typically do not even have copies of the family law orders. What they have is a duty of care. So they have a duty to provide instruction to students, and a duty of care to take reasonable care to prevent avoidable injury to a student. So if they are provided with a copy of a current family law, there is a duty on the school to take some steps to ensure that the student's welfare is protected. So that's the welfare of the student, not what mum or dad are interested in happening for the student. So the very fact that there might be a family court order in place and dad turns up at the school to collect the child, there is no obligation, even if dad's not allowed to collect the child, there is no obligation on the school to try to wrestle the father to the ground or to try to remove the child from the father's grasp, anything like that. Absolutely no obligation on that on the school whatsoever. If that occurs, however, and the school has been provided with a copy of the family law order that says dad is not to take the child, dad turns up and takes the child. If that is observed by the school, they do need to do something about that. So they shouldn't just observe dad, who is not allowed to take the child, taking the child and do nothing. If they're confident that they have the current family court order, which is the other issue, if it's a family court order that's 12 months old, the duty is going to be different than if it's a family court order that was made last week. So if it's a family court order and it's made last week, dad turns up to take the kids, the appropriate reaction of the school is going to be to probably call the police or at the very least to call mum and to say to the mum, look, the dad's just turned up. But does the school have an obligation to intervene? No, it doesn't. There's absolutely no obligation on them to monitor or check off or inventory which student has gone home with which parent and is it the right day. For example, if there's a family court order that says dad picks the kids up Monday, Tuesday, Wednesday and mum picks up Thursday, Friday, there is no obligation on the school to police that and to make sure that the right parent picks the student up. If the student appears to be willingly going with the parent who has turned up, then the school hasn't done anything wrong. That said, if you have a parent come to you who is concerned about making sure appropriate steps being taken within the school to fulfil that duty of care, what you can help that parent to do is to prepare their some communication to the school, basically, to give the school a copy of the court order. The parent needs to tell the school that it is a current court order. The parent needs to tell the school what it would like the school to do in the event that it appears a breach is about to occur. So that scenario of dad turns up at the school to take the child. What does mum want the school to do that doesn't involve wrestling dad to the ground or somehow abducting the student and locking them in a room somewhere? Does mum want the school to call the police? Does mum want the school to call mum? Does mum want the school to call somebody else? So coming up with information, first thing the parent needs to do is provide the school with some information about the orders. How does the parent who is sitting in front of you want those orders to operate in practice? And then thirdly, what happens? What does that parent want the school to do when things seem to be going in the wrong direction? So come up with a nice, sensible communication that deals with those three areas and help the parent prepare that so that they can pass that through to the school. And you will find that the schools will comply where it's presented in that manner. Unfortunately, as I say, what typically happens is that a parent will say to the school, I have some orders and this is what the orders say, but the school has no way of knowing whether that's true and no way of knowing when those orders are replaced. So there are some very, very sensible reasons why schools do not, should not, and will not enforce family court orders, but they can be of assistance so long as the communication is carried out in a very sensible way.
Can I just clarify? You talked there about parenting orders in the family law jurisdiction. It would make sense that it's exactly the same process for domestic violence orders where children are named on those orders?
Absolutely, yeah, exactly the same process. So if you've got a domestic violence protection order that, you know, one parent, I can say that I'm going to say mum, but mum shouldn't go near kids. Again, it needs to be exactly the same process of the parent who has the benefit of the order communicating it, setting up a strategy for how that's going to be applied in practice and what's to happen when that goes wrong. I'll talk now about child safety concerns, because there are some, so in the sense that family law, there are no actual obligations other than a duty of care around family law. It's the complete opposite for reporting of child safety concerns. There are obligations on teachers to report child safety concerns. They are very serious obligations. They carry with them potential penalties against teachers if they don't comply with their child safety reporting obligations. There are a number of sources of the obligation. So the first source is the Education General Provisions Act, which has put in place a requirement that any member or any staff member of a state school, so that's anybody in the school, any staff member of a state school, or reasonably suspects in the course of their employment, so it has to be something that's relevantly come up through the employment, that a student under the age of 18 or a student with a disability, but 18 is being the age, that's really relevant, has been sexually abused by another person, and that's anybody. So it's not just somebody in the school abusing the child, it's sexual abuse by anybody. Or, and it's a separate section that deals with a student is likely to be sexually abused by another person. Very difficult sort of set of terminology, likely to be sexually abused by another person. They must report that information immediately to their principal. If the principal has received that information, they must report it immediately to the police. So there's no time for sitting around and thinking about those child safety obligations. The staff member must report it immediately to the principal, and the principal must report immediately to the police. Now, the effect of that can be that information which is not information about actual sexual abuse gets reported to the police. But what the staff members of the school are doing are reporting to police that they have been told information that raises a reasonable suspicion of sexual abuse. They're not telling the police that it's true. They're not telling the police that it has happened. They're telling the police that they have received information that suggests that might occur. And what all of the schools tell their employees, private and public, all schools tell their employees that if in any doubt, they must report because of the consequences of not reporting. If they receive some information, they're not really sure whether it points to sexual abuse, they don't report it and a student continues to be abused, that's an absolutely tragic outcome that the schools and educational authorities simply do not accept anymore. And they are very, very clear. They tell their staff anything that might be sexual abuse must be reported immediately. So it's a really, really heavy obligation, and it's an obligation that the schools push down onto their staff members in a very significant way. There are also obligations, so that obligation only applies to school staff. There are also obligations under the Child Protection Act, and they apply not only to teachers but police officers, nurses and doctors, and that relates to reporting of child harm. And this is a requirement to report to the Department of Child Safety, that any information about a risk of harm to a child must be reported. Now, if this legislation is slightly more complicated. Harm means significant harm, so it's got to be something that's not a trivial level of harm, but some significant harm. But it can include It includes physical or sexual abuse. It can include anything that might result in significant harm to a child, and that might include significant psychological harm to a child. There is a bit of an exception. So the reportable suspicion only applies to a child who has suffered, is suffering, or is at an unacceptable risk of suffering significant harm caused by physical or sexual abuse and may not have a parent able and willing to protect the child from the harm. So the scenario where you have a student who regularly turns up to school with no socks, appearing not to have been fed, you know, no homework, hair not brushed, all of that kind of thing, and you have a concern about, or somebody has a concern about neglect for that child. If the school feels that they can say to one of the parents, look, you've got to have socks, you've got to brush the hair, you've got to, you know, feed your child before they come to school, the parent says, oh yes, okay, I'll do all of those things. Well, there's no reportable suspicion there because you've spoken to the parent seems to understand and we'll fix it up. If it's a situation where the school speaks to the parent seems not to care. A common scenario can be it might be, you know, mum and dad aren't together anymore. There might be a new relationship. The new partner isn't interested in the health and well-being of the children from this previous relationship, and the biological parent is feeling under pressure and can't properly provide for the child. In that scenario, there will be a reportable suspicion, and they must make that report to the Department of Child Safety. So lots of obligations around reporting. They are very serious obligations. They come with very serious consequences for school staff who do not comply. So it's not only a breach of the legislation for a staff member to not comply with the reporting obligations, it's also a breach of their terms and conditions of employment. And for teachers who are registered teachers, it's also potentially something that their registration authority, which is the College of Teachers, can look at. So more often than not, the scenarios you'll be faced with will be complaints from parents about an over-reporting of problems, either to police or to child safety, or complaints about the school dobbing on the parents. Unfortunately, there just isn't very much that can be done about that. The parents are entitled to contact child safety, entitled to contact police, of course, to find out information about the nature of the allegations. There are protections in the Act which mean that, for example, child safety information, if a member of staff at a school provides a child safety notification, child safety should not, if you look at the legislation, should not release that information to the parents. It does happen from time to time, but the obligation on child safety is they are supposed to keep confidential certainly the name of the notifier and any information that would identify the notifier. But apart from identifying the notifier, the parents are entitled to have a look at the nature of the complaint that's been raised about them. I think that, yep.
Rachel, questions come through about the suspicion and, you know, the decision-making process that might feed into that. What kind of guidance do teachers have around what might happen in the future and how they can make that judgment?
Yeah, okay. It's very difficult. So some of these relate to future harm, so likely to be sexually abused and unacceptable risk of suffering harm in the future. Very difficult for teachers or school staff generally to make judgments about that sort of thing. The Royal Commission into Institutional Responses to Child Sexual Abuse has done a lot of work looking at reportable suspicions and when reportable suspicion, why things go unreported. So basically the Royal Commission is going around looking at cases where there was insufficient or non-existent reporting of sexual abuse, even though information did come to the school's knowledge. So it has done a lot of work on looking at the reasons why notifications aren't made, and even it recognises it's very hard. Into the future, it's very hard to predict. Pieces of information that students, and sometimes we're talking about quite young students who don't always present things in a clear and complete manner. Teachers have to, and school staff have to make a call about whether or not the information they've received is likely to relate to some form of abuse. So it's very, very difficult, but you can guarantee if information is received, the school will be pushing the staff member to report.
And the reality is, as lawyers, we advise teachers when in doubt, just report every time. Because we actually have cases where in the past teachers have reported and have been told that they should have reported at that level and have later faced disciplinary action because they hadn't reported. So it really is an area that it's just become so difficult that you just have to report any information that you get as a teacher.
About reporting sexualised behaviour of young children, so not evidence of sex abuse per se, but sexualised behaviour.
The school staff members will need to make a judgment about sexualised behaviour as opposed to abusive behaviour. Sometimes sexualised behaviour can represent, it's a reflection of behaviour of the child, which is either being encouraged by someone who might be abusing the child, or it's mimicking behaviour that's being displayed to the child. I think police would probably say that it can sometimes reflect children being shown inappropriate material, which is an indecent dealing, criminal offence of indecent dealing. The school staff do just have to make a call about that kind of thing. If they, in their experience, think that the level of sexualised behaviour probably just represents, maybe it represents QB, it represents, an ordinary stage of, or perhaps an escalated version of an ordinary stage of development, then they can reach their own conclusion that maybe that doesn't have to be reported. But I'd have to say, if it makes the teacher or the staff member pause and think that's unusual behaviour, if they go to their principal, I could guarantee you their principal would say, look, let's just do a report and we'll let somebody else investigate whether or not that represents some form of sexual abuse, because the school doesn't have the capacity or the skills to investigate things like this, whereas child safety and police do. And that's the rationale, is that information can come through the school that needs to be investigated, and it might be nothing, it might be completely normal, but it has to be investigated by somebody who has the resources, and that's either police or child safety, not school.
Eddie, maybe a technical question. Is the principal required to issue a written notice of suspension for a 4-week suspension, or of verbal reasons?
It has to be a written notice. A written notice explaining the reasons as well.
Thank you. Just a reminder, folks, you can ask questions by typing them into the questions box or putting up your hand. Looks like we're going to go a little bit over time because there's so much content we've been dealing with here, but it's all really great, so please do stick with us if you can.
I'll be quick now. I'm just talking about social media, Facebook defamation, which is one of the most fun parts of our job, because we get to see all kinds of interesting comments being made online. I'll just give you a quick definition of defamation, which you may or may not know. Defamation occurs where one person communicates by words, photographs, videos, illustrations, or other means material which has the effect or tendency of damaging the reputation of another. Now, as that applies to teachers, as you'll understand, a teacher's reputation in the community is pretty important, and defamation can have a very serious effect on them and their careers. Now, what parents need to understand, and I guess when people are coming and speaking to you, is when they're putting something on Facebook or social media, they're publishing it. They may as well be producing their own independent newspaper. As far as the law of defamation is concerned, once they put it online, it has been published. So if they're, the old rule we used to have was never send an email when you're angry and wait until the next day and think it over. With social media, that doesn't even apply now. People just get on there and say what they're thinking, and the next thing you know, they have to defame somebody. There's a guy, John Wooden, I think he was a basketball coach. He's that famous quote, the true test of a man's character is what he does when no one is watching. And what you find with Facebook and social media, whenever people are on there, nobody's watching what they're doing or saying. And the advice to parents has to be that it is a very key area for them. Of course, truth is a defense to defamation, but how sure of the sort of things that they may or may not be saying on Facebook can they really be? And it's not the correct forum to make any sort of serious accusation anyway. Now, what we tend to do from our perspective for teachers when they have been defamed is issue letters. I'll just read you out a typical passage of the sort of standard letter that we initially sent to parents. So we are instructed to inform you that it would be open to our client to institute proceedings for damages for defamation against you in the court. At this stage, our client has not proposed to do so, but has instructed us to make it clear, as we do, that all of our clients' rights against you are expressly reserved in relation to any defamatory statements which you may have made in the past or may make in the future. Our client's instructions to us not to institute proceedings at this stage in no way involves any waiver of their right. If there is any repetition of the defamatory statements, our client will instruct us to institute proceedings immediately. Our client reserves the right to rely on this letter in any court or other forum. Now, just for your own information, we have been having internal discussions here about whether we will continue to issue those letters if we will actually go straight to defamation actions in the future. So it is an area that you really, I mean, I guess it's probably unlikely that a parent will come to you and ask, oh, should I get online and flag off the teacher? But if you do get the opportunity, or if it does become a topic of conversation, they really must be aware of how dangerous it can be for them. There is actually a section of the criminal code as well that holds imprisonment for up to 3 years. That's section 474.17 of the Criminal Code Act 1995, which is the Commonwealth Act. And that refers to using a carriage service to menace, harass, or cause offence. Carriage service, of course, can be telephone, can be Facebook, can be Twitter, can be Instagram, although I struggle to see how you could do it on Instagram, but anyway. And a person will be guilty of an offence if the person uses a carriage service and the person does so in a way, whether by the method of use or the content of communication or both, that reasonable persons would regard as being, in all the circumstances, menacing, harassing, or offensive. Now, we've had cases where parents have gone online and said, you know, such and such has treated my kid in this way. I'd like to punch them, or I'd like to see how they treat me if I was standing in front of them. And that's a menacing, harassing, or offensive statement. And look, it's unlikely that they're going to go to jail for 3 years, but the fact is it's in there, it's in the criminal code, and a charge could be laid against them if the circumstances were particularly bad. The reality is, of course, defamation law is only really effective against somebody who has assets, because it's a civil action and it's designed to you know, get money basically for the damage to the reputation. But it can cause an awful lot of stress and worry, and there is going to eventually be a case where a teacher will follow through and take the parent to court for the things that have been said online. So I really think it is an area that parents need to be aware of.
Terrific. That brings us to the end, I think, of the prepared remarks that Eddie and Rachel have put together. I think we've kind of mapped an entire landscape of a whole heap of things that you might be seeing in community legal centres across Queensland when parents or students come in and talk about experiences at schools. We're pretty much bang on time, but if you do have questions, feel free to send them through. Either type them through on the questions box or put up your hand on the control panel. Can I ask, guys, if you've had much to do with the use of restricted practices on students with disability?
Restraint, physical restraint?
That type of thing.
Yeah. Okay, it's an interesting area. So most teachers are trained in what they call non-violent crisis intervention strategies, which does involve physical restraint of a student. Now, if a teacher uses those non-violent crisis intervention strategies to physically move or restrain a student, then that's within the course of their employment, and it's unlikely to be something which is looked at closely. A teacher who loses their temper, however, hits a student, does something physically inappropriate to a student, that is the sort of thing that parents commonly do get upset about. I think that the main things are to make sure that the parent has got the right information from their child about the type of force that's being used and what circumstances it was applied. We have come from my parents' generation and perhaps your parents' generation, assumed that all children lied all the time. We've come to a place now where we believe every word that our children say is true. So there's a bit of a pendulum swing there, and I think something in the middle is probably the more accurate position. But so what parents need to do first of all is to make sure that they understand properly from their child, and they believe their child about circumstances in which that physical force was applied and about the nature of the force that's used. So if it's in a scenario where their child was being aggressive towards another child and the teacher has pushed them out of the way, even not using those non-violent crisis intervention strategies, that's not going to be something that, for example, police would be interested in looking at. But if it's a situation where a teacher has lost their temper and has reacted in a physically violent way towards a child in a school, for no good reason, the parent is entitled to take that to police and ask for investigation.
And not to contradict Rachel there, as she is my superior, but police will investigate any of those sorts of claims. There is a general defence for teachers in terms of how they handle kids if it is about the safety and well-being of themselves or the other students, but that won't stop police interviewing the teacher to establish whether that has been the case. So for parents coming in that have genuine concerns, police will always investigate it.
I think the term you used there, Rachel, was non-violent crisis intervention. One of our participants has asked, is that the same as therapeutic crisis intervention? Are they interchangeable terms? Do you know? Have you always called it non-violent?
I don't think that's the same. I think that might be different. I don't know therapeutic crisis intervention. Certainly the state schools typically send people off for training in the non-violent crisis intervention.
Yep. That's
the most common thing that's used in the special education area. I don't know therapeutic.
Yep. No, that's fine. Questions coming through around, again, restrictive practice is kind of the overbearing thing, but where a child is, sorry, let me rephrase that. The parent comes in to see us and says that their child is tied to a chair, put in a cage or something like that, otherwise secluded. Folks, it's a shame we're not showing the video because the place just about hit the table there.
Well, we did have one where a child was put in what the teachers called the cage. It wasn't a cage, it was a gate between
the kids referred to it.
The kids referred to it as the cage and went home and told the parent that they'd been put in a cage. So it's not beyond the possibility that parents will come in with those sort of complaints.
Unfortunately, that kind of thing does happen. So the teacher who puts masking tape over a student's mouth because they're talking too much, the teacher who ties a kid to their chair because they can't seem to sit still, those are real things and they do happen, sadly. They're not appropriate things to happen, they are potentially ignored matters. The parent would need to make a decision about how they want to deal with it. I'd have to say involving a child in a police matter is probably not the best first step. What the parent should do is make an appointment to see the principal of the school as soon as possible. If they can't see the principal, see a deputy. If they can't see a deputy, then they might need to go to the police. But get in and see a principal or a deputy within a couple of days of that happening. The sooner the better. If you can do it the same day, all the better. and report those concerns to that parent, the principal or deputy. The principal or deputy will take it seriously and will investigate that. If the parent feels that the school is not taking it seriously, or they're protecting the teacher, that's when they will need to go to the police and they're not going to have a choice. But I'd have to recommend that first step is speak to the principal or the deputy just to see what's going on. So is it the scenario of it's not really a cage, it's just a gate that the teacher closes and the kids call it a cage, or is there really a cage there somewhere? And that can be sorted out at the school pretty quickly. But do it immediately. Make sure the parent feels that they're getting a proper response from the school. If they don't feel they're getting a proper response, that they'd have to go to the police.
Terrific. Folks, on behalf of everyone clapping and cheering wildly at phones and computers across the state, can I thank Eddie and Rachel for, as I said, a really a huge variety of issues that we might see in community legal centres, for giving us really practical steps when people come in and see us about those things. Yeah, I think we'll be much better equipped to deal with those queries when parents and students come in. I'm seeing some thank yous come through on the GoToWebinar here, so I echo the participants. Thank you both. And thanks everyone who tuned in today. We'll look forward to speaking to you soon. Bye.
Thank you.
Thank you.